On a Thursday afternoon in October, at approximately 2:17 in the afternoon, my daughter and son told the police that I had pushed them. Vera said she had been standing in the kitchen doorway when I came toward her and shoved her with both hands, causing her to fall and strike her shoulder on the doorframe. She had a bruise on her shoulder when the police arrived. The bruise was real. I could see it, a dark oval against her collarbone, the specific color of a bruise that is several hours old. Daniel said he had been coming into the house when I struck him across the face. He had a mark on his cheek when the police arrived. I could see it, the redness that had been applied with something. A hand, perhaps, though not mine. They were both crying. The crying was real in the sense that real tears were produced, though the quality of the crying, the specific intermittency of it, the way it intensified when the police officer was looking at them and subsided when she was not, was a quality recognized from their childhoods. They had been able to cry at will since they were approximately 9 and 7, respectively, which had been useful to them across the decades of their lives. I was sitting in my armchair in the study when the police arrived. I was sitting in the armchair because I had been sitting in the armchair since approximately 1:45, when I began my afternoon meditation. I had been sitting in the armchair in the study with the door closed for 32 minutes when Vera and Daniel called the police. The study is on the second floor. The kitchen is on the first floor. The distance between my armchair and the kitchen doorway is approximately 45 feet, not counting the stairs. I am 79 years old. I am 79 years old. I have bad knees. I can manage the stairs, but the managing takes time. Approximately 90 seconds to descend them carefully, and approximately 2 minutes to ascend them. I had not left the armchair since 1:45. The police officer was a young woman named Officer Delgado, who had the specific quality of someone who listens to all parties before deciding what she thinks. She listened to Vera and Daniel, and she came upstairs and she listened to me. And she looked at the armchair, and at the study, and at me, and at the stairs. She said, "Miss Sabo Whitfield, your children are making a serious allegation." "Yes," I said, "they are." "Do you have anything you'd like to tell me about what happened this afternoon?" I told her I had been in the armchair since 1:45. I told her about the knees. I told her about the meditation. "Can anyone confirm that?" she said. I looked at my wrist. "Yes," I said. "My name is Rose Miriam Sabo Whitfield. I am 79 years old. I was a biomedical data analyst for 28 years at a research hospital in Minneapolis, and I retired in 2017. And the specific nature of my professional training is the nature of someone who has spent 28 years understanding what physiological data means and what it proves and what it cannot prove. I had been wearing my Apple Watch since I woke up that morning at 6:15. I held my wrist toward Officer Delgado. "I have the data," I said. I want to explain the watch's data before I explain anything else, because the data is the technical center of the story, and because explaining it correctly requires more precision than popular accounts of smartwatch capabilities typically provide. The Apple Watch records physiological data continuously during use. The specific data streams relevant to the October afternoon are heart rate measured by optical photoplethysmography at the wrist, blood oxygen saturation measured by the same optical system, three axes, and is used to derive step counts, activity classification, and the detection of significant physical events. The heart rate measurement is continuous in the sense that the watch takes readings approximately every 5 minutes during periods of low activity and more frequently during periods of elevated heart rate or detected movement. The heart rate data is time-stamped with 1-minute precision in the standard export, and with greater precision in the raw health data that is available through the Health App's data export function. The accelerometry data is continuous at a high sampling rate during periods of detected movement. During periods of inactivity, sitting, lying down, the accelerometer continues to record, and the recording captures even small movements, including the specific signature of breathing, of the hand settling against the armrest, of the head nodding. During meditation, the data from the October afternoon showed the following. Between 1:45 and 2:43, which was when Officer Delgado arrived at my door, my heart rate ranged from 63 to 67 beats per minute. The mean was 65. The variability pattern was consistent with the parasympathetic dominance that meditation produces. Slow, regular, the specific cardiac rhythm of someone whose autonomic nervous system is in the resting state. If I had stood up, walked to the door, descended the stairs, crossed the kitchen, and physically assaulted two people in their 50s, my heart rate would have shown a very different pattern. Activity of that kind, unexpected, physical, emotionally charged, produces a heart rate response that begins within seconds of the exertion and takes several minutes to return to baseline. My heart rate had not moved outside a 4 beat per minute range for the entire 98 minutes of the record. The accelerometry data showed between 1:45 and 2:31, I had made 0 steps. My accelerometer signature during this period was the signature of someone sitting still, the slow oscillation of breathing, an occasional small hand movement, the specific stillness of a person who has been sitting in the same position for an extended time. At 2:31, I had made 12 steps, which corresponded to my walking to the study window when I heard a noise from downstairs. At 2:38, I had made 9 steps, which corresponded to walking to the study door when the sound of voices became more prominent. I had not descended the stairs until Officer Delgado arrived and asked me to come down, at which point the accelerometer recorded 47 steps, consistent with descending to the first floor. I had not been within 45 feet of my children at 2:17. I was certain of this because I had been in the armchair since 1:45, which the watch's data confirmed exactly, and because the stairs took 90 seconds and the distance between the kitchen doorway and the staircase took another 30 seconds, and because I had made 0 steps between 1:45 and 2:31. The data was specific, time-stamped, and unambiguous. The question of my children's watches was a different matter, which I had begun thinking about as Officer Delgado stood in my study. 28 years as a biomedical data analyst is 28 years of reading what physiological measurements say about what a body is doing and what a person is experiencing. This is the professional background that makes the watch's data not just evidence, but specifically legible evidence. Own state, I came to biomedical data analysis through the back door of nursing, which I had practiced for 12 years before returning to graduate school for a master's in biostatistics. The nursing years had given me the clinical foundation, the direct knowledge of what physiological parameters mean in the context of a patient's body, the understanding of normal and abnormal ranges, and the conditions that produce them. The biostatistics training had given me the analytical tools to work with large physiological datasets and to extract from them the specific signals that are meaningful among the noise that biological measurement always produces. The research hospital where I worked for 28 years was a teaching hospital associated with the University of Minnesota's medical school, and the work I did there was primarily in the analysis of clinical trial data. The large data sets generated by studies of cardiac medications, respiratory interventions, metabolic conditions, and the various other areas where the hospital's research groups were active. The data I worked with daily included heart rate, blood pressure, oxygen saturation, respiratory rate, and the various other physiological parameters that clinical researchers collect to understand how a treatment is affecting a body. I had also worked for the last decade of my career with wearable device data. The data collected by the consumer health monitors that had become prevalent in the 2010s and that were generating by the time I retired in 2017 an enormous volume of 17 physiological information about people's daily lives. The wearable data was, in research contexts, a new kind of evidence, continuous, longitudinal, collected in the real world rather than in a clinical setting, and therefore capturing things that clinical measurements could not capture, including physiological responses to daily activities, stress, sleep, and exercise, as they actually occurred rather than as they could be approximated in a laboratory. I had written 2 papers on the use of consumer wearable data in research contexts. Both had been published in peer-reviewed journals, and both had been cited in subsequent work by other researchers. The papers were not primarily methodological. They addressed the specific question of what consumer wearable data could and could not validly tell us about physiological states, which is the question that matters most when you are proposing to use the data as evidence of anything. What consumer wearable data could validly tell us, I had concluded in the papers, was a great deal. The heart rate data from a modern smartwatch is accurate to within a few beats per minute under conditions of low to moderate motion artifact, and it is continuous enough to show physiological trends over time with good fidelity. The accelerometry data is very accurate for step counting and activity classification. The combined data, heart rate plus accelerometry, can, with appropriate analysis, distinguish between different behavioral states with high reliability. What the data could not tell us was the subjective experience of the person wearing the watch. It could tell you that a person's heart rate was 65 beats per minute. It could not tell you whether they were at peace or in distress, whether they were happy or sad, whether what they were thinking was true or false. The body's data is the body's data. The mind is a different matter. The distinction mattered enormously in the October proceedings, and I want to name it clearly. The watch data proved I was sitting in the armchair. It did not prove why I was sitting there, what I was thinking, or what my intentions were at any moment. The watch is a witness to the physical, not to the psychological. What the physical witness demonstrated, in this case, was the specific and sufficient thing. That the physical event my children claimed had occurred had not occurred, because the physical evidence of the person they claimed had committed it showed no trace of the physiological signature that would have accompanied it. The proof of absence is not always available in these situations. In this situation, it was, the mind is where the interest of the October afternoon's data resided. My children's watches had also been recording. I want to tell you about Vera and Daniel honestly, because the honest account is the one that is true, and because I am a person who has spent 79 years preferring the true account to the comfortable one. Vera Saba Whitfield is 53 years old. She is the elder of my 2 children, and she has the specific combination of intelligence and restlessness that makes people alternately impressive and difficult. The intelligence that takes problems apart quickly, and the restlessness that makes it hard to stay with solutions that require patience. She had 2 marriages, both of which ended in divorce, and she works as a real estate agent in the Phoenix area, which suits her. The work is fast-paced, transactional, and rewards the ability to read people and situations quickly. Daniel Saba Whitfield is 49 years old. He is quieter than Vera, which is not the same as gentler, quieter in the sense of someone who speaks less and acts later, but the acting, when it comes, is as decided as Vera's. He works in financial services in Chicago, the specific end of financial services that manages estate assets and wealth transfers, which is the professional context that I believe shaped the specific character of what he and Vera planned. My husband Edgar Whitfield died in 2021 at 81 from the cardiac condition that had been managed for a decade and that finally was not manageable. We had been married for 52 years, and the marriage had been what I would call genuinely good in the full sense of that phrase. Good in the daily texture of the life, good in the capacity to endure difficulty and maintain something real on the other side of the difficulty, good in the specific accumulation of understanding that long marriages produce. Edgar left a will. The will had been prepared by an estate attorney in Minneapolis in 2018 and had been reviewed and confirmed in 2020 and was, as wills go, straightforward, the house and the substantial investment account to me, with specific bequests to both children and a charitable bequest to the hospital where I had spent my career. The children's bequests were real and significant. Each received approximately $200,000 in investment assets, transferred immediately upon the will's execution. The house and the investment account, the larger assets, passed to me. I had moved to Phoenix in 2022 after Edgar's death because the Minneapolis winters had become what they become when you are 76 and alone and have knees that object to cold. Less manageable, Vera was in Phoenix. The house I rented in Phoenix's north side was near enough to Vera's house that we could see each other regularly, which we did. The regularly seeing each other had produced across 2023 an increasing frequency of conversations about the house, the Minneapolis house that I had not yet sold, which was in good condition and which the rental market had made more valuable than the direct sale market, and which I was managing remotely with the assistance of a property management company. The conversations were not about the Minneapolis house exactly. They were about my assets more generally, about what would happen to the house and the investment account eventually, about whether my estate planning was current and appropriate. Daniel had come to Phoenix for several of these conversations, flying in from Chicago on weekends that he described as visits, and that had the specific quality of visits that are organized around a purpose. I had been in my industry for 28 years. I understood what data looked like when it was telling you something. The conversations were data. The data was telling me something. I want to be precise about what the data was telling me, because precision is what my professional training demands, and because the imprecise version of this account, I suspected my children wanted my money, is both true and insufficient. The specific character of the data was 2 adult children who had received significant bequests from their father's estate and who had stable careers and adequate incomes were directing their attention toward the remaining estate with the specific urgency of people who believe the remaining estate is at risk of not flowing to them in the way they expect. The urgency was out of proportion to the circumstances. I was 79 and in good health. There was no immediate reason for urgency. The urgency, I concluded, was being driven by something other than genuine concern for me. I had spoken to my own estate attorney in Minneapolis by phone in July. I had asked her to review the estate documents and to confirm that they were current and that they reflected my actual intentions, which they did. I had also asked her in a second call in August what a competency challenge would look like, the specific legal process by which someone could attempt to have another person declared incompetent to manage their own affairs. The information she gave me about competency challenges was the information I had been assembling mentally since June. The watch had been on my wrist every day since May of that year, when my physician had recommended it for cardiac monitoring. I wear it to bed. I wear it during meditation. I wear it during everything. I want to be precise about what I knew before October, because precision about sequence and evidence is what my professional training demands, and because the story requires it. I knew that Vera and Daniel were interested in the estate. This was observation, not inference. They had told me directly, across the conversations of 2023, that they were concerned about the estate's management. The specific concerns they had articulated were about whether I was handling everything properly, and whether I had thought about the future, and whether I might want help with the management of the assets. These phrases are the phrases of people who want access to assets and who are framing the want as concern. I knew that Vera had done some research on the process by which a court can appoint a guardian or conservator for an elderly person. I knew this because she had asked me questions across 2 conversations that were not the questions of someone who is generally curious about elder law, but the questions of someone who has read a specific article or consulted a specific resource. The questions were specific and sequenced in the way that questions are specific and sequenced when they come from a prepared agenda, rather than from organic curiosity. I knew that Daniel had access to information about competency challenges through his professional work in estate asset management, where such challenges are a component of the legal landscape that estate professionals encounter. He had mentioned in passing 2 cases in which conservatorships had been established, and the mentioning had been the kind of mentioning that is not really passing. That is placed in conversation with a purpose. I did not know specifically what they were planning. I had concluded from the observation that they were considering something, some action, that was oriented toward gaining control over the estate or some portion of it, and that the competency challenge framework was the mechanism they were most likely to use. But the specific form the plan would take was not something I had foreseen. The fake fall. The staged physical incident with bruises and marks that had been prepared in advance and that were meant to demonstrate violent and disordered behavior on my part was more dramatic than I had anticipated. It was also, in retrospect, evidence of the same dynamic that had characterized the conversational approach. The appearance of genuine evidence designed to produce a specific institutional response, without the reality underlying it. I had been prepared in the general way. I wore the watch continuously because my physician had recommended it, and because I understood its data capabilities. I had been prepared in the specific way that someone who has spent 28 years working with physiological data is prepared. I knew what my watch was recording, and I knew what it would show. I had not anticipated October, but the preparation I had made was the right preparation for what October brought. Officer Delgado was in my study for approximately 20 minutes. She had a tablet with which she was taking notes, and she asked questions in the careful sequence of someone who has been trained to gather information before forming conclusions. She asked me to describe my afternoon. She asked about my relationship with my children. She asked about the knees. She asked whether I had any medical conditions that might affect my behavior or my memory. I answered all of her questions directly and without embellishment. I am not a person who embellishes. My professional training is in data, in what the numbers say and what they do not say. And my personal inclination is toward precision, which means I say what I mean and mean what I say and do not add the rhetorical decoration that people sometimes add to make things more persuasive. When she asked if I had anything that could confirm my account of the afternoon, I showed her the watch and I showed her the health application on my phone, which displays the heart rate and step count data graphically. The graph of heart rate from 145 to 243 was a near horizontal line at 65 beats per minute. The step count for the same period showed 0 steps from 145 to 231. Officer Delgado looked at the graph. She is not a biomedical data analyst, but she is also not someone who cannot read a graph. A flat line is a flat line. This is your heart rate, she said. Yes, I said. During the period your report will say the incident occurred, my heart rate was 65 beats per minute. If I had gone downstairs and physically assaulted 2 people, the heart rate would not look like that. What would it look like? She said. You would see an increase beginning approximately 30 to 60 seconds before the physical exertion, as anticipatory arousal raises the heart rate. During the exertion, you would see it continue to rise. After the exertion, it would take 5 to 15 minutes to return to baseline. For an altercation involving physical force, you would expect a peak heart rate of 120 to 160 beats per minute, depending on the individual's fitness level. The data shows no such pattern. The data shows 65 beats per minute, flat, for the full 98 minutes. She looked at the graph again. Then she said, "Do your children wear smartwatches?" "Vera wears a Fitbit," I said. "Daniel wears a Garmin." I have seen both. Officer Delgado made a note on her tablet. She thanked me and she went back downstairs. I did not hear the conversation she had with Vera and Daniel downstairs. I heard its general shape, the tone of voices, the rising quality of Vera's contributions, the lower and less frequent sound of Daniel. I sat in my armchair and I waited. After 40 minutes, Officer Delgado came back upstairs. She said, "Ms. Saba Whitfield, I am not placing you under arrest. I'm going to include your watch data in my report. The situation will require further investigation." "I understand," I said. "Your children have given statements that are inconsistent with what your watch shows," she said. She said this carefully, in the way that police officers say things that are significant, without saying more than is appropriate to say at the stage of an investigation. "Yes," I said. "I expect they are." She left. I sat in the armchair for another hour. Then I called my attorney. My attorney is a woman named Barbara Okonkwo, who practices elder law in Minneapolis, and who has been handling my estate matters since 2015. I had called her in July about the competency challenge question, and she had given me the information I had asked for. And she had also, with the specific caution of an attorney who was listening to a client describe a situation that sounds concerning, asked whether there was anything specific I was worried about. I had told her what I had observed. The conversations, the questions, the research that Vera seemed to have done. She had said, "Rose, if you think a competency challenge is being planned, you should document your current cognitive and physical status with your physician, and you should know that your estate documents are current." "Both of those are true?" "Both of those are true," I had said. "Then your legal situation is solid," she had said. "A competency challenge requires medical evidence that you cannot manage your own affairs. Your physician's assessment is the primary evidence. If your physician's assessment is that you are competent, the challenge is very difficult to sustain." I had continued the conversation, and Barbara had given me the additional information I needed: what the legal process looked like, what my rights were, what the evidentiary standards were. She had said one other thing that I had thought about frequently in the months since. The people who bring competency challenges against a competent person rely, almost always, on the difficulty of proving a negative. They assume you cannot prove you were somewhere else or doing something else at the specific moment they choose. The challenge is designed to put the burden of proof in a place where proof is difficult to produce. I had thought about this after the call. I had looked at my wrist. The watch was recording, as it always recorded, the continuous story of my body in real time. On the evening of October, I called Barbara and told her what had happened. She was quiet for a long time after I finished. Then, "They staged an incident to accuse you of assault in order to establish a pattern of violent or disordered behavior that could support a competency petition." "That is my assessment," I said. "The watch data," she said, "is definitive," I said. "I can export the full raw data set from the health application. The accelerometry data shows my position in the chair for the full period. The heart rate data shows meditation-level cardiac activity. The combination is, in my professional assessment, irrefutable." "Watches," she said, "are potentially equally interesting," I said. "If Vera and Daniel were staging a performance, coordinating the incident, managing the physical props, performing the emotional distress, their heart rates would not look like mine. Performance, particularly performance of a high-stakes planned deception, produces physiological arousal." "Can you obtain their watch data?" she said. "Not directly," I said, "but in a legal proceeding, it could be obtained through discovery. Their watches were recording during the same period as mine. The data exists." Barbara had been practicing elder law for 30 years. She had the quality of attorneys who have seen many configurations of family conflict around estates, and who do not shock easily. She was quiet for another moment. Then she said, "Rose, I think we should file first. Proactive action establishing the facts of the October incident on the record before anyone else files anything. And a report to Adult Protective Services about the staged incident, which is a form of elder abuse that APS investigates." "Yes," I said. "The watch data is going to be the center of everything," she said. "Yes," I said. "I know. I've been wearing it since May." The proceedings occupied 8 months. I will describe them in the summary terms that are honest without being exhaustive, because the details of legal proceedings, while important, are not the interesting part of the story. The interesting part is what the data showed and what the showing meant. Barbara filed the proactive complaint in November, 2 weeks after the October afternoon. The complaint documented the staged incident and my watch data and requested that the court make a formal finding about the incident's nature. The complaint was filed in an Arizona court because Arizona is where the incident occurred and where I reside. The Adult Protective Services investigation was opened simultaneously. APS in Phoenix has an elder abuse unit, and the unit assigned an investigator who interviewed me. Interviewed Officer Delgado, reviewed the watch data, and subsequently sought to interview Vera and Daniel. In December, a data analyst engaged by Barbara, a woman named Dr. Priya Mahajan, who had been a research scientist at Stanford before entering private expert witness practice, analyzed the health application export from my watch and produced a report. The report was 22 pages, formatted as an expert declaration, and it addressed the technical specifications of the Apple Watch's physiological sensors and their accuracy, the specific data recorded on October afternoon, the physiological interpretation of that data in the context of the claim that I had engaged in physical exertion, and the statistical significance of the difference between the observed data and the data that would be expected if the claim were true. Dr. Mahajan's conclusions were: 1. The Apple Watch data showed no physiological evidence of physical exertion during the period from 1:45 to 2:31. 2. The heart rate data was consistent with meditation or similar resting state activity. 3. The accelerometry data was inconsistent with walking, stair descent, or any significant physical movement during the same period. 4. The probability that a person engaged in the physical activity alleged could have produced the observed heart rate pattern was, under the physiological models applicable to a person of my age and fitness level, less than 1 in 10,000. Vera and Daniel retained counsel. Their counsel argued that consumer wearable data was insufficiently reliable to serve as evidence, that the data could have been manipulated, and that the physiological models Dr. Mahajan had applied were overly general. These were legitimate arguments, and I do not dismiss them. Consumer wearable data is not a perfect physiological instrument, and there are valid questions about its accuracy and reliability. What their counsel's arguments could not fully address was the discovery request. Barbara had filed discovery requests for the data from Vera's Fitbit and Daniel's Garmin for the period from 2 o'clock to 3 o'clock on the October afternoon. Their counsel had opposed the request on grounds of relevance and privacy. The court had ordered production. The Fitbit data for Vera showed the following. Beginning at approximately 2:04, her heart rate had risen from 72 beats per minute. Her resting rate, established by the preceding hour's data, to 107 beats per minute. It had reached a peak of 119 beats per minute at approximately 2:15, at which point it had remained elevated for approximately 20 minutes before beginning to decline. The accelerometry data showed significant movement during the same period. The Garmin data for Daniel showed a similar pattern, with a slightly earlier onset. Beginning at approximately 2:01, his heart rate rising from his resting rate of 68 to a peak of 114 at approximately 2:14. The physiological profile was consistent with significant physical and emotional exertion, the preparation and execution of a planned performance under conditions of emotional stress. In contrast, my heart rate at the same time was 65 beats per minute, flat. Dr. Mahajan produced a supplemental declaration after the discovery data was obtained. The supplemental declaration addressed the comparison between my watch data and my children's watch data, and it was the most technically specific document produced in the proceedings. She had constructed what she called a physiological narrative for each of the 3 people, a reconstruction of the physiological events of the October afternoon based on the watch data interpreted in light of the physiological models applicable to people of each person's age and baseline condition. My physiological narrative. At 1:45, I had sat down in the armchair and entered a period of physical rest and reduced cognitive engagement consistent with meditation. My heart rate declined from a pre-sitting level of approximately 72 beats per minute to the meditation baseline of 65. My accelerometry showed a transition from low ambulatory activity to the minimal movement signature of sustained sitting. Both measurements remained stable for the full duration of the period, with no evidence of any physical event or emotional arousal. Vera's physiological narrative. From approximately 1:45 to 2:04, she showed a resting pattern consistent with a person engaged in quiet activity. Reading, sitting, similar sedentary behavior. Beginning at 2:04, her heart rate began to rise. The rise was gradual rather than the sudden spike that typically characterizes unexpected physical exertion or unexpected emotional response. A gradual rise beginning approximately 10 minutes before the claimed incident time is consistent with the anticipatory arousal of a person who knows something is about to happen and who is preparing for it. The peak heart rate of 119, occurring at the claimed incident time, was consistent with the physiological state of active performance under conditions of emotional stress. Daniel's physiological narrative. Similar to Vera's, with an even earlier onset of the anticipatory rise, beginning at approximately 2:01. His earlier onset, Dr. Mahajan noted, suggested that he may have initiated the physical preparation that produced the bruise and mark before Vera did, that he may have been the one who applied the physical evidence rather than Vera, consistent with his earlier cardiovascular response. The declaration concluded, "The physiological data from the three devices tells a coherent narrative that is inconsistent with the narrative presented by the adult children and consistent with the narrative presented by Rose Sabo Whitfield. The data indicates that the adult children experienced significant physiological arousal beginning approximately 10 to 13 minutes before the claimed incident time and peaking at the claimed incident time, while Rose Sabo Whitfield's physiological data showed no significant arousal at any point during the relevant period. This pattern is consistent with the hypothesis that the adult children planned and executed a staged incident while Rose Sabo Whitfield remained seated in her study." I read this declaration in Barbara's office on a February afternoon. The reading took 40 minutes. When I finished, I put it on the table and I was quiet for a moment. Barbara said, "The declaration is strong." "Yes," I said, "the data is what it is." "Are you all right?" she said. She asked it the way good attorneys ask it, not as a courtesy, but as a genuine question about whether her client is prepared for what is coming. "I am 79 years old, and my children staged an incident to have me committed," I said. "I am not all right in the sense that no one is all right when something like this has happened. But I am all right in the sense that I know what the data shows, and I know what it means, and I am prepared to present it." "Good," she said. "Good," she said. The evidentiary hearing was held in April before a judge named the Honorable Patricia Chen, who had been on the Maricopa County Superior Court bench for 11 years and who had the specific quality of judicial attention that good judges have. Willingness to engage with technical material carefully rather than defaulting to a lay summary of it. Dr. Mahajan testified for 3 hours. She explained the technology, the data, the analysis, and the interpretation. She was cross-examined for 2 hours. The cross-examination covered the accuracy of consumer wearables, the potential for data manipulation, the generalizability of the physiological models, and the specific alternative explanations that Vera and Daniel's counsel had developed. Dr. Mahajan answered each question in the specific way that good expert witnesses answer cross-examination, directly, with the precision appropriate to the question, neither overstating her conclusions nor retreating from them when they were challenged. The judge asked questions directly, which is not universal. Some judges let counsel handle the examination entirely. Judge Chen asked 3 questions, each of which was specific and precise. She asked about the accuracy of the Apple Watch heart rate measurement specifically, which Dr. Mahajan addressed by citing 2 peer-reviewed validation studies. She asked about the baseline heart rate comparison between subjects, which Dr. Mahajan addressed by explaining that each person's data was compared to their own prior baseline. And she asked about the timing precision of the data, which Dr. Mahajan addressed by explaining the timestamp methodology and its accuracy. Vera and Daniel's expert, a technology consultant named Mr. Fraser, testified about the limitations of consumer wearable data. His testimony was competent and some of his points were valid. Consumer wearable data is not infallible. Infallible. But his testimony could not address the fundamental pattern that Dr. Mahajan had presented. 3 people's data, telling a consistent story that supported one account and not the other. I testified for 90 minutes. I described my afternoon, the meditation, the armchair, closed door, the niece. I described my professional background and the specific nature of my expertise in physiological data interpretation. I was cross-examined for 40 minutes, and the cross-examination focused primarily on whether I had manipulated the watch data, which I had not, and whether my interpretation of the data was influenced by bias, which it was not in any way that my professional training would recognize as methodologically significant. I was asked in the cross-examination whether I loved my children. I said yes. I said it simply and without elaboration, because the question was simple, and the answer was simple, and elaboration would have made it less true rather than more. I was asked whether I believed my children had deliberately staged the October incident. I said that the data was consistent with that conclusion, and that I would not speculate beyond what the data supported. The judge looked at me when I said this with the expression that I have come to associate with judges who have just heard a witness distinguish between what they know and what they believe, in the way that the distinction deserves. The hearing concluded at 3 p.m. Judge Chen issued her ruling from the bench, which is not universal, but which she did because she said the evidentiary record was sufficiently clear that a delayed written ruling was not necessary. She found the physiological data established by a preponderance of the evidence that Rose Sabo Whitfield had not engaged in the physical conduct alleged by her children on the October afternoon. That the children's physiological data, combined with the inconsistencies in their statements, was consistent with a staged incident, and that the staging of a false incident to support a competency challenge against an elderly person constituted elder abuse and defamation under applicable Arizona law. The referral to the county attorney for criminal prosecution was included in the ruling. The criminal proceedings are not mine to describe in full, because criminal proceedings involve the criminal justice system's processes rather than mine, and I am not the principal actor in those processes. What I can tell you is what I know and what is in the public record. The county attorney's office filed charges of elder abuse, filing a false police report. Defamation. These charges are standard in situations where a staged incident against an elderly person has been established by evidence. The specific criminal statutes in Arizona carry ranges of penalties that I will not specify, because the sentencing, if it comes to sentencing, is the court's decision and not mine. Vera and Daniel entered guilty pleas in October of the following year, 1 year after the October afternoon that had produced the whole sequence. The pleas were to reduce charges negotiated with the county attorney, which is a common resolution in cases where the evidence is strong and the defendants are first offenders. The specific terms of the plea were not disclosed publicly, though the record shows that both received suspended sentences, required restitution, and were ordered to complete a program of supervised counseling. I had been asked by the county attorney's office whether I supported the prosecution. I had said yes. I had been asked whether I wanted to submit a victim impact statement. I had said yes. The victim impact statement I submitted was shorter than most. It said, in full, the October incident was an attempt to have me removed from my own life on the basis of evidence that was fabricated. The attempt failed because the evidence of my own body, recorded by a device I wear every day, was more reliable than the testimony of people who believed I would have no recourse. The harm I have experienced is not primarily the legal process which I navigated, as I have navigated other complex problems, with the tools available to me and with patience. The harm is the knowledge that the people who planned this are my children, and that the planning required them to believe I was a problem to be solved rather than a person to be respected. I hope the process the court has imposed on them produces something that is genuinely useful to them. I do not know whether it will. I had not said anything in the courtroom directly to Vera and Daniel. I had not needed to. The data had said what needed to be said, and the court had interpreted it correctly. There is a sentence attributed to me in the court proceedings that I will address directly. The heart doesn't lie, only your greedy brains do. I did not say this in court. I am not the kind of person who says things like this in court, and if I were, my attorney would have advised against it. What I said in the victim impact statement was what I have quoted above. The attributed statement appears to have originated from a summary of the case that circulated on social media, and that added rhetorical flourish to an account that did not require it. I note this not to deny that the sentiment behind the statement is one I understand. The heart's data is the body's truth, and it did not support what my children claimed, but to be accurate about what was actually said, and by whom. The watch data said what the watch data said. The interpretation was the court's and Dr. Mahajan's. My statement was what it was. It is January now. I'm sitting in the armchair in the study. The watch is on my wrist. The heart rate display, which I can see by tilting my wrist, reads 67 beats per minute, which is my resting heart rate in the morning when I have had my coffee and have not yet begun the day's physical activity. The data is continuous. It is recording now, as it records always, the specific physiological story of a 79-year-old woman sitting in a study in Phoenix, her heart doing what hearts do, and her accelerometer registering the specific stillness of someone at rest. I have thought across the months since October of last year about what the experience means, what it says about data and about the body. Than a person. The thinking has been the thinking of someone who has spent 28 years working with physiological data, and who brings a specific professional lens to the question of what such data can and cannot tell us. What the data told us in the October proceedings was specific and narrow. It told us where my body was and what my body was doing at a specific time, with a precision that exceeded the precision of memory and exceeded the credibility of testimony. The data is not biased. The data is not invested in any particular outcome. The data is the recording of physical reality as it occurred, at the sampling rate of the instrument, with the accuracy that the instrument can achieve. This is what data always is. This is why the profession I spent 28 years in matters. Because data, properly collected and properly interpreted, tells you things about the world that other kinds of evidence cannot tell you with the same reliability. The watch data told me something I already knew, that I had been sitting in my armchair. But it told it in a language that a court could evaluate, and that a judge could rule on. The question I have been sitting with across the months is not the legal question or the physiological question. It is the simpler and harder question. How does a family arrive at the place that Vera and Daniel arrived at? What is the sequence of decisions, the small accommodations of conscience, the gradual recategorization of a person from parent to obstacle, the specific moment when the plan becomes concrete. That leads from the ordinary complications of adulthood, children and aging parents to a staged October afternoon. I do not have a complete answer. I have observations. The observations are that the recategorization of a person from someone you love to something you manage is a gradual process, not a sudden one, and that the gradualness is what makes it possible. Each small step is defensible within the framework the person has constructed, and the framework is adjusted to accommodate each step until the framework bears no resemblance to the one that existed at the beginning. Vera and Daniel did not wake up one morning and decide to harm their mother. They arrived there through a sequence of decisions, each of which was accommodated by the previous one, and the arriving was gradual enough that they may not have noticed how far they had traveled from the place they started. I do not say this to excuse what they did. I say it because it is true, and because understanding what is true about how people arrive at harmful places is the thing that might, in some cases, help other people not to arrive at those places. What do I know at 79, after the watch and the data and the hearing and the year? I know that the body keeps its own record, and that the record does not lie in the technical sense that physiological data is not susceptible to the distortions that memory and motivation introduce into testimony. The heart rate at 65 beats per minute is 65 beats per minute. The 0 steps from 145 to 231 are 0 steps. These facts are not negotiable. I know that data by itself is not wisdom. The watch data told me where I was and what my body was doing. It did not tell me why my children did what they did, or what it means, or what comes next. Those questions require something different from data. They require the sustained engagement with what is true about people, and about love, and about the specific damage that money can do to relationships that should be organized around something else. I know that the appropriate response to an attempt to erase your life is to document your life. I wore the watch because my physician recommended it. I am glad I wore the watch because of what the wearing produced. The preparation was not strategic in the sense of being aimed at this specific outcome. I did not know October was coming. The preparation was simply what a person who pays attention to their own physiological health does, and the data it produced was available when the data was needed. Be present in your own life. Record what the recording captures. Understand what the data means. These are not strategic principles. They are the habits of a person who takes her own existence seriously. The watch reads 67 beats per minute. It is reading me exactly as I am. On this January morning, I am here. The data confirms it.